Awesome. Go ahead and call this meeting to order. The Maricopa County Board of Adjustment, April 13th, 2023. Rosalie, would you please do the roll call?
Chairman Loper.
Here.
Vice Chairperson.
Here.
Member Ward.
Here.
Member Cardin.
Here.
Member Schwartz.
Here.
Chairman, we have a quorum.
Thank you very much. Move on to the minutes. Has everybody had a chance to review the minutes from March 16th last month? And if so, are there any comments or questions or changes? Seeing none, seeing all nods no, they're approved. Move on to the announcements. Number one, this meeting has been noticed in accordance with the open meeting law of ARS 38-431. Agendas are available within 24 hours of each meeting in the Maricopa County Planning and Development Office and are also available on the Planning and Development website 1 week prior to the hearing at www.maricopa.gov/planning. With respect to the hearing process, cases will be considered on the agenda in the order they appear unless otherwise agreed to by the board. And we have no changes to the agenda as of right now. For each case, the applicant will be given a set amount of time to present their testimony. Any witness wishing to give testimony on a particular case shall notify the board of such interest. This shall be done by filling out a speaker's card. If you're here in attendance and you want to speak on an item, make sure you get one of these from Rosalie and fill it out. Thank you. Or registering desire to comment as noted on the published agenda for those appearing virtually or online. Also, at the appropriate time for each case, the chair will ask those attending in person and online who wish to speak to a case to raise their hand by clicking on that icon on the webinar screen. Staff will provide the chair with the names of persons who have registered and noted a desire to comment, and those registered participants who have raised their hand. The chair will call on each named participant one at a time. Such testimony shall be limited to a maximum of 3 minutes. However, the actual amount of time allowed to testify shall be at the discretion of the board chair. The chair will conduct the hybrid in-person and virtual public hearing according to the bylaws and according to the rules established by the chair regarding public comment. Votes will be done by roll call vote only, and the chair will verbally identify the specific members responsible for all motions and seconds. Move on to the consent agenda. We have 2 items on the consent agenda. Turn this over to Darren.
Mr. Chairman, board members, the 2 items on consent are BA 2023-006, known as the Siddiqui property in District 3. The request is for variances to the east side setback, terrace height and setback, and hillside disturbance outside the lot's principal building envelope at 7540 North Redledge Drive. There's no known opposition. The findings in paragraph 19 are that it meets the statutory test for approval subject to items A through C. And then BA 2023-015, the Williams property in District 4, requested variances to lot area and lot width for property at 15025 North 71st Avenue. There is no known opposition. The findings in paragraph 18 are that it meets the statutory test for variance approval subject to items A and B.
Thank you very much. Are there any questions of board members to staff? No one's presented a speaker card. Webinar team, is there anyone who's indicated a wish to speak on either of these items?
There is no one who's wished to speak.
Awesome. All right, then go ahead and turn over to the board for a motion and second.
I motion that we accept the consent agenda as presented.
We have a motion for approval of the consent agenda by member Ward. Is there a second?
Second.
And we have a second by member Cardin, or not Cardin. I was looking at you, Craig, sorry. Member Person. Rosalie, if you go ahead and take a roll call vote.
Member Cardin.
Yes.
Member Schwartz.
Yes.
Member Ward.
Yes.
Vice Chairperson.
Yes.
Chairman Loper.
Yes.
Chairman, that's an approval by a vote of 5-0.
Congratulations to the applicants. All right, we'll move on to the regular agenda, or I'm sorry, code compliance review. Item B, 2021-00112. And staff, you go ahead and present the case, please.
Yes, Mr. Chairman, board members, V 2021-00112 is code enforcement review for a violation alleging construction of an accessory dwelling unit without permit or clearance and parking storage of a semi-truck, which is a non-accessory vehicle greater than 10,000 pounds for property in District 4 at 3509 North 359th Avenue. The property owners and respondent are Sean and Michelle Holly. This case was opened in January 2021 due to citizen complaints regarding parking and storage of a non-accessory vehicle greater than 10,000 pounds gross vehicle weight in a rural residential area and construction without permits, clearance, and failure to meet setbacks, again, for a building that had been set up as an accessory dwelling unit. The respondent entered into a compliance agreement where they admitted responsibility for the violation and for bringing the property into compliance. However, the terms of that agreement expired on October 25th, 2021. Therefore, the case was subsequently scheduled in 2022. Summons was sent scheduling a administrative hearing for the hearing officer, and that was held on January 5th, 2023. And the hearing officer found the respondent, the property owner of record, responsible for the violation. As of January 31st, the respondents appealed for code enforcement review, and they're represented by counsel. I'll note that the hearing officer made a finding of fact and reached conclusion pursuant to section 1502 of the county zoning ordinance and pursuant to article 1504.3.2 of the ordinance. The board may either affirm the hearing officer's order of judgment or remand it back to the hearing officer due to a finding of procedural error in processing the case before the hearing officer. Staff has reviewed the record and believes the evidence supports the decision of the hearing officer and finds no administrative or procedural errors. Therefore, we recommend that you affirm the hearing officer's order of judgment. And I'm happy to answer any questions you may have.
Thank you, Darren. Are there any questions of staff by any of the board members? Member Person.
Thank you, Darren. Yeah, my question, and I'm probably jumping ahead, but can you just explain the relationship between this case and the following one on the regular agenda? Is this, we just have to take care of them separately, and one is then to deal with this as a permanent solution?
Yes, Mr. Chairman, Member Person, they are the same site and property owners. The following case will, if it were approved, would remedy a component of site zoning violations, but not solve the entire situation. And I can speak to that case in more detail when we get to it.
Any other questions of staff at this time? I just have one, just really, Darren, to confirm our role in this process. We've had a number of these. It's not to rehear the case. It's really to see if there was something procedural that was amiss, and if so, remand it back. But that's what our purview is just the procedural portion of it, not the merits of the case itself.
Mr. Chairman, yes, that is my understanding to be correct, and county council's here and can speak to that.
See our attorney nodding his head. Thank you very much, Darren. All right, we'll go ahead and open the public hearing. And is the applicant's representative here?
Just state my name and address. Okay.
Please.
Peter Furlow, 7144 East Stetson Drive. We have to slide up. The only thing I want to correct from what Darren said is they were unrepresented in the violation hearing on January 6th. But you can go to the next slide. Timeline was given. You can go to the next slide. So we'll start with relevant Maricopa County ordinances. Essentially, why this is important is because the whole case was decided on whether the property is ag exempt or not. Planning and zoning has the power to ag exempt, not the assessor. You can go to the next slide. On the Maricopa County website, you're supposed to receive a map of what's exempt and what's not. Any improvements that are shown on the map They'll say if they're ag exempt or not. Applicants have never received that. Next slide. So in the ag exemption that the Hollies received, said that all the pre-existing improvements currently on the site from September 2021, can you still hear me? From September 2021 were ag exempt. What's important is no improvements or no changes have been made to the property since that time. Hearing was in January after the ag exemption. So that's why I included that and why it's relevant. It includes the two buildings that are at issue for the violations, for the 3 violations. They concern 2 buildings. Next slide. So this is directly from the record. The hearing officer asked the Maricopa County representative, can you describe to me the portion of the property that does or does not have an ag exemption? The response was, from what I understand, and this may not be 100% correct, I'm going to draw on here what was roughly shown to me by the assessor's office. For the record, there's a rough guess. I don't have the exact dimensions. From the 26 to 27 minute mark, the county representative modified the exemption map that he drew and introduced into evidence for the first time. At the 1 hour and 8 minute mark, the hearing officer asked the county representative how the ag exemption would affect the decision on those 3 violations. He basically said, if it's exempt, meaning the violations would go away. At least in terms of past violations, it'd be a very important factor. Then the other part I wanted to include is from the 10 to 15 minute mark, the opposition, not the applicant, not the hearing officer, was examining the county, which, as you'll see, next slide. This is in here. It might not be relevant to procedure, but I just wanted to point out emails from the assessor that basically confirmed the Maricopa County zoning ordinance that I cite to, where they say, we have absolutely no authority to exempt. That's a role of planning and zoning. So in the hearing, county said, this is what the assessor says is exempt, but it's actually planning and zoning who exempts buildings. Next slide. So this is procedural errors necessitating remand, which is what we're asking for today. The first one I already mentioned. The second one's been mentioned as well, that the only map that's required by the county to be provided to the applicants to show what is and is not exempt has never been provided to them. For 3, the applicant didn't receive the evidence or the hearing packet until about 5 minutes before. That's at the 1 minute mark. That doesn't give them time to prepare for their own hearing. 4, county failed to send required notice of the violation hearing until after they retain, legal services, and I had to request that for them. They would have missed their appeal deadline if they weren't represented by an attorney, which I think is unacceptable. County failed to provide myself or the Hollies any of the evidentiary packets or the audio recording of the violation hearing to prepare for this today until April 7th. I asked on January 19th and February 1st, which on the next slide or 2 slides from now, you'll see those emails. And then 7, the hearing officer acknowledges that the ag exemption is an open question in the hearing itself, but does not grant a continuance. So the main question that underlies all of the violations was unanswered and it didn't get continued. So in the interest of justice, it should have been continued until that was solved. Next slide. So here I cite to the Maricopa County Zoning Ordinances, which is chapter 15, which controls on conduct of these hearings. So they violated 1504.3.5, that no person may be examined at a hearing except by the hearing officer, defendant's attorney, designated representative, the zoning inspector, or county attorney. Opposition was given 5 minutes to examine the county representative. For F of the same ordinance, a record of the proceeding shall be made by audio tape. That's true, it was made by audio tape, but it wasn't provided to applicant, nor was it provided to me, who represents them as legal counsel, even after multiple requests. So they also violated right to appeal, which is 1504.3.7. So it's that the hearing officer shall deliver to the defendant written notice of his right to appeal to the B of A. That wasn't provided until after the appeal timeline had already expired, if you were going based off the 10-day timeline from the hearing. Continuance, I spoke to that, but it's cited at 1504.3.4 and 1504.3.8. Copies of all evidence submitted at the hearing and a copy of the audio tape of the hearing needs to be provided. I already mentioned no audio tape until after or until April 7th. And as far as evidence that was submitted, I haven't received any copy. Next slide. What's highlighted is just 2 emails, one on January 18th and one on February 1st, where I asked the county for a transcript of the original hearing, or if there's any way to access the recording for the January 5th hearing. Again, if I would have received those at that time, it would have been nice, would have given me extra time to prepare for, this code compliance, but instead I get it on April 7th after having to follow up a third time. Next slide. So our request, therefore, because the entire decision was based off of a misstatement of the law, because of all the procedural errors that I laid out, I think this necessitates remand so that we can have another hearing. We can actually answer those open questions that are there on the, that they're being cited for these violations. Thanks.
Thank you very much. Are there any questions by board members of the speaker? All right, seeing none. This is a public hearing. Is there anyone else who wishes to speak on this item? Anybody here in person? Seeing none. Anybody online?
There is no one online.
Okay. All right, then we'll close the public hearing and turn it over to board members for questions of the of each other or of Darren. Cannot speak today. County staff. Member Person.
Thank you. Yeah, Darren, I'd just like to hear the county's position on what Peter just shared on the violations.
Yes, Mr. Chairman, Member Person, I'll try and hit the items raised. There is an agricultural use that has been confirmed by the department for a miniature horse farm that's operating on the property. But uses that are on the property are ag exempt. There's not necessarily dimensions. So I can see why that would confuse staff at the hearing. The uses may occupy certain dimensions, but it is the uses. So we do not consider the single family residence to be exempted. We wouldn't consider an accessory dwelling unit to the residence to be exempted. Farm worker housing would be part of the agricultural use. We didn't consider the semi truck that's being used for long haul trucking business to be part of the agricultural use. Although I understand it has brought hay in to the horses on occasion, but there are also vendors that have brought hay in to the horses. But that's something we can address specifically in the next case. So the violation had 2 components. One was the storage of the non-accessory truck. The other was unpermitted construction, which I understand was change of occupancy of an accessory building so that it became an accessory dwelling unit. If that was something that was considered to be part of the agricultural use, then the fact that it doesn't meet the minimum 3-foot setback for an attached accessory structure could be part of that exemption. So that was presented to the hearing officer. The respondent, the property owner, was present at the hearing online and participated in the hearing. The hearing officer, subsequent to the administrative hearing, found them responsible. He sends his order and staff forwards that order to the involved parties. And that's when a copy of the order and a copy of, right to appeal would be presented. It's not necessarily based on the hearing officer, the hearing date. It could be based on the date of the hearing officer's order, but if we send it via email, we'll always allow that email date to be where the 10-day count starts from. Obviously, that was not an issue because the appeal has been processed and you're here today.
What about the opposing counsel getting the ability to, and that's probably more of a question for Wayne, but getting a chance to question the hearing officer?
The normal course of procedures is staff will present. Staff may be represented by county counsel, and we will ask, so there will be testimony given and questions. The other party, which would be the defendant or respondent, could ask questions of the person giving testimony. And then the hearing officer turns it over to the defendant or respondent to give their testimony, and staff and or county counsel can ask questions. That is what occurred at the hearing. And again, they were not represented by counsel at the hearing, they were represented by counsel today.
Darren or Rachel, would it be possible to go back in the slides to the one where it listed, you were looking for the one where it listed one more. The one before this one.
There was two of them, right? Procedural errors. Okay, so can you hear me now? Can I speak? Okay. So Darren, would if there was dimensions on the agricultural lines, would that have potentially changed a decision or looked at differently by the hearing officer?
Mr. Chairman, Member Schwartz, I can't really speak to the hearing officer's decision making. I would think not, because the land use, the agricultural use can constantly change, especially when it's regarding animals. There could be new fencing, new animal enclosures. The fact that this is on a property that also contains housing, the area that they set aside for horse pens and horse corrals could change. But again, it's the entire property is subject to an agricultural exemption for the agricultural uses. So it's not, which may be a little different than the assessor. The assessor may decide taxes based upon dimensions, where they'll carve off an acre for the house and the rest will be taxed differently. But that's separate from the zoning question.
So, one more question. So, and maybe it's for Wayne. So if this moves forward with an approval, the applicant will have the opportunity to go in front of a judge and talk about all these issues and try to get remedy there?
Mr. Chairman, Member Schwartz, yes. The Board of Supervisors by statute is authorized to allow appeals from hearing officers either to itself or to the Board of Adjustment. Maricopa County Board of Supervisors has elected to give that privilege to you, but has limited the scope of your review to procedural errors that impact the decision made by the hearing officer. If this matter were to go to court, the statute provides that it's done pursuant to the Administrative Appeals Act, and the judge will review the record to determine whether or not there was sufficient evidence in the record to substantiate the decision that the hearing officer made. It's not a weighing and a balancing. It's not, well, the judge saying, well, if I were the hearing officer, I would have decided differently. The only question is there enough in there? And I'll remind the board that the applicant admitted to the violations when they signed the compliance agreement. If I just may, Darren was explaining it, but it's very confusing. In the area of property tax, the assessor makes a determination that the property is of sufficient size, has been put to agricultural use for a sufficient term, and is in fact engaged in those things that are described as agricultural. That gets the property an exemption for taxes. That is a prerequisite to getting, in Maricopa County, to getting a separate exemption from zoning because you are agricultural. In other words, rather than go out and do a new analysis, planning and development relies on the assessor's initial determination that it qualifies as ag. But the ordinance also provides if you are then engaged in uses on the property that are not agricultural, those are not exempt from zoning. They may not get taxed for the house because they have a different standard, but for zoning purposes, the use is not related to the agricultural. That's why it's a violation. One other thing I'd like to point out, the council may be correct that he did not receive a transcript, but the transcript is irrelevant for this appeal because you don't review the transcript. Council has pointed out what he believes to be procedural errors, one of which is that proper notice was not given of the hearing. Under the law, if you appear at a hearing without raising that as an issue, you've waived it. In addition, council has said they were not given notice of their right to appeal. Attached to your packet is the January 9th judgment and orders of hearing officer, and the last paragraph provides, in accordance with the procedures for civil hearing and review of hearings, MCZO Chapter 15, you have 10 business days to file an appeal to the Maricopa County Board of Adjustment. So that notice was in fact given. If anything else, I'll be happy to answer.
No, that was very clear and concise for me. Thank you. I have one more question. Can you pull up the next slide? Yeah, maybe stay up there just in case I need you. Okay. There was something in here about somebody that got to speak that potentially shouldn't have been able to speak.
It was alleged that,
Yeah.
Mr. Chairman, Member Schwartz, it was alleged that members of the public who were objectors questioned the county's witness, which is not provided for. If that is true, it's for you then to decide whether that was somehow affected the decision of the hearing officer. I believe if you read the hearing officer's order, it says based on the admission and the testimony, nowhere does it indicate that he relied in any way on any third party.
Thank you.
Anyone else have any questions of staff this time?
Chairman
Ward or
Loeffler?
Darren?
I do.
Go ahead, Member Ward.
Thank you. And I guess this would probably also be addressed to Mr. Peck. So the respondent requested time to resolve the violations on April 4th, per the paper, per what I see here, the synopsis. So April 4th, then it moves on to that expired on October 25th. So we're talking 6-8 months there. Then it moves on that we don't hear from them again for a year. And nothing was ever accomplished, it seems like. I guess I'm a little confused. Can you please, I don't even know what my question is. I'm sorry. It just seems like that is the part of it that we should be talking about, is the time frame. Am I
Mr. Chairman, Member Ward, really the only issue that you would be considering is anything that happened from and after January 6th, the date of the hearing, and January 9th. If there were a lag between the expiration of the compliance agreement and bringing the person in for hearing, that could just be the fact that code enforcement's very busy, or there may have been telephone conversations, I don't know. But with all due respect, that's really outside the parameters of what you're looking at today.
Okay. Okay. So nothing prior to the January hearing. Thank you. Sorry.
That's okay. Thank you, Member Ward. Any other questions? All right, I'll turn it back over. Did I close the public hearing? If I didn't, I am closing the public hearing. Turn it back over to the board members for discussion and or a motion. What district is it?
Chairman Loper,
Yes.
If we find a procedure, if we remand it to the hearing officer due to a finding of procedural error, do we need to actually name the procedural error?
That would be correct if that was the motion. We really have two motions in front of us. Well, three. One can be a continuance, but either affirm the hearing officer's determination or remand it back to the hearing officer, but based on a procedural error that occurred. So those are really our three different options today. And thank you, Wayne.
Chairman, may I address the question? Anytime the board makes a decision, it's supposed to put on the record the basis for it. From a practical standpoint, if you were, and I don't think we've ever had this happen, if you were to remand it because you found a procedural error, it would be helpful to know where the error occurred. But what would happen is, because of due process considerations, I would recommend that we start the process again. But that doesn't mean that somebody might not file an appeal from your remand. So it's always helpful, if it were to go to court, for the court to know on what procedural error you found. If I confused you more, I apologize, but typical lawyer answer, it depends.
Anything else, Fern? Okay. All right. Member Schwartz.
Yeah, I'll make a motion if that's okay with you, Fern.
Definitely.
I move that we affirm the officer, the code compliance by the officer with no procedural errors.
All right, we
I
have a
will second
motion
that.
to affirm the hearing officer. Is there a second?
I will second that.
We have a second by Member Ward. Rosalie, would you please take roll call vote?
Member Cardin,
Yes.
Member Schwartz,
Yes.
Yes.
Member Ward,
Yes.
Vice Chairperson,
No.
and Chairman Loper.
It's really a tough one, but I'm going to go with yes.
Chairman, that's to affirm the hearing officer's determination by a vote of 4-1.
Thank you and best of luck in your pursuit of this particular issue. We move on to the regular agenda. Number 4, TU 2023-014, parking of a semi-truck. Mr. Johnson, I'll turn it over to you and rest of the staff for presentation.
Mr. Chairman, board members, before Daniel goes into his presentation, he will indicate that the staff recommendations for denial, and I want to point out primary reason for that is because staff believes this requires a special use permit for a cottage industry, which could be a long-term entitlement. The category for a temporary use permit to remedy as an exit strategy for remedying a violation requires that it's part of a plan of compliance codified in a compliance agreement. And we do not have a valid compliance agreement with the Hollies at this time.
Thank you.
Thank you, Chairman and members of the board. Case TU 2023-014 is a request by the property owners, Michelle and Sean Hawley, to store their commercial vehicle inside an enclosed shop in Supervisor District 5. The site is located at 3509 North 359th Avenue in the Tonopah area, and the site is zoned Rural 43 and is approximately 9.7 acres. On January 26, 2021, code enforcement sent initial notice of violation V2021-00112 for parking of a commercial semi-truck and flatbed trailer in a residential zoning district. On March 10th, 2021, code enforcement site inspection found violations on the subject property involving one commercial business operating in a rural residential zoning district without the proper zoning entitlement and parking and storage of a non-accessory vehicle over 10,000 pounds. Department sends owner notice of violation in order to comply on March 16, 2021. By September 13, 2021, the owners receive agricultural exemption under land use case number LU 2021-0077 for a miniature horse farm, exempt from county zoning authority. Non-agricultural uses are not exempt. On January 5th, 2023, after the administrative hearing date for violation V2021-00112, the hearing officer found the property owners responsible for the violation of unpermitted construction, not part of the agricultural use, and for commercial business and parking of a non-accessory vehicle, the semi-truck, not part of the agricultural use. The hearing officer's order included daily non-compliance fines to accrue if deadlines were not met until compliance is verified. No fine amount has been paid to date. The request, if approved, will allow the property owner to park the commercial semi-truck and trailer that has been used in the operating of the farm and used additionally in the owner's fry business in an existing fully enclosed building while not in use. The TUP is only requesting for parking and storage of the semi-truck and trailer and will not include the transport of freight to or from the property, except for hay, horses, or cattle as required. The length requested is 6 months. The applicant stated in application documentation that the significant investment in trucks, trailers, and equipment for moving freight of all kinds doing business as Will I Miniatures Transport, a subsidiary of Will I Miniatures Farm number 7274. The agricultural exemption currently granted to the subject site does not include the operation of a freight business from the property. The findings, staff is concerned with the length of time the violation had been unresolved on the site regarding the commercial business and use of the semi-truck for the separate commercial use. A special use permit has yet to be filed for the freight business that would cover the extended use of the commercial vehicle subject to violation V2021-00112. Staff also has concerns regarding the use of unimproved 359th Avenue handling the high commercial weight of a semi-truck and trailers. Similar concerns voiced in opposition refer to dust creation in the commercial vehicle damaging the road. Staff is in the opinion that 359th Avenue cannot handle the commercial weight of a semi-truck and attached trailers. The use of a semi-truck in a rural residential neighborhood also draws safety concerns for neighborhood residences who use 359th Avenue as the only road and access to other parts of the area, frequently used by pedestrians and equestrians. The site was posted in accordance with Maricopa County Zoning Ordinance Article 1302.3.1.3 with the required 10-day public notice period. Starting on March 10, 2023, the 10 days expired on March 17, 2023. Staff received 4 memos of public opposition to the application signed by 6 property owners. The applicant provided staff 8 memos in support of the request signed by 9 property owners. 1 letter of support was anonymous. On March 20th and 27th, 2023, the applicant provided staff with an exhibit of semi-trucks being stored on the residential properties in the neighborhood and letters of support from area neighbors. This is included in the report to the board. On April 11th, the applicant provided an additional petition of support with 7 signatures and an additional letter of support provided as a handout to the board prior to this hearing. Staff has received in total 18 letters of support and requests for the request and 6 in opposition to the request. Neighborhood opposition to the request documents the commercial vehicle with trailers managing multiple point turns to enter through the 21-foot gate that serves as the primary entrance to the property. While doing so, blocking the only access to county paved maintained Indian School road for several property owners who use 359th Avenue to access their properties. The neighborhood falls within the radius of 10 miles surrounding Palo Verde Generation Station, where evacuations could be required to protect the public from the effects of exposure to radiation, of which the semi-truck can potentially block the only evacuation route out of the property of the neighborhood. Opposition also centered on the commercial freight business's continued operation with the approval of this temporary use permit or future entitlement. Opposition voiced evaluation of property values due to the commercial business operating in the residential neighborhood without an entitlement. Staff is in the opinion that the applicant has not satisfied requirements of Maricopa County Zoning Ordinance, Article 1302.3.2 regarding other temporary uses. The proposed use creates adverse impacts on surrounding properties and residents. The Board of Adjustment may only approve a temporary use permit by stipulating additional requirements, provided that said stipulations substantially reduce all such adverse impacts, and as such, staff recommends denial of the TUP. Reviewing county agencies do not have objections to the request. Staff asks the board to consider mitigating factors be conditioned if the board considers approval of the request, including having the alternate entrance points used to bring the commercial vehicle and trailers to the subject site that does not interfere or block any easement or right of way at any time, restricted delivery hours, resolve all the open violations on the property in a timely manner, and a deadline to apply for and obtain either the appropriate entitlement or SUP approval as a condition of approval of this temporary use permit. For the reasons outlined in this report, staff recommends the board to motion to deny TU 2023014. However, if the board chooses to approve the request, staff offers conditions A through H as provided in the report to the board. At this time, I'll be happy to answer any questions.
Thank you, Daniel. Very thorough report. Are there any questions or comments by any of the board members of staff at this time? Not at this time. All right, go ahead and open the public hearing. May have some in a bit. And public hearing is open, and is the applicant or applicant's representative here? Go ahead and provide your name for the record, please, and then proceed.
Michelle Hawley.
There's a question for you before you begin by Member Schwartz.
Hi, Holly. Hi, how are you?
Good, how are you?
Good. So I know that you just brought on legal representation, and I'm hearing staff that there may be some alternative options for you here. And rather than, at least was my thought, rather than having you go through that exercise of explaining this, that maybe if it would be all right with the rest of our with the rest of our board and with you and your attorney to maybe spend 30 days and go work with staff, maybe they can find you a great option so you can continue to do what you're trying to do. Because I'm not sure, I'm just hearing obviously that there is other options. You have counsel, he seems very bright and articulate. And if there are other options for you to close the loop on some of these items, that maybe that might be a better way to proceed. And if you decide that you can't do that and you want to proceed further, then that's fine also. I don't know if I'm out of order, but I just think that from what I'm hearing by Darren's explanation, by staff's explanation, that might be a real worthwhile opportunity for you to solve the problems.
The only reason why we decided with the TUP is to give us time to apply for the special use, because I know the special use takes quite a bit longer to get with just how you have to submit so much more. So what do you think on, may I ask?
Absolutely.
Who to?
Mr. Chairman, Member Schwartz, I believe Ms. Holly's aware that what staff is suggesting to remedy the violation is one of three things: either apply and obtain a special use permit, and that's ongoing. If they're going to work on a special use permit, they've had time to work on a special use permit, and that doesn't necessarily require a continuance. You can decide today they can still come in for the special use permit. The fines are accruing. Secondly, they could just simply move the truck somewhere else to a truck terminal and operate out of that truck terminal, or document that the truck is less than 10,000 gross vehicle weight, which I don't believe would be the case.
Yes, and there's a question by Member Person. Give us a moment here.
Darren and Daniel, I have a question, again, as it relates back.
Ms.
go
Member
ahead.
Person, I don't believe that respondent, the applicant can hear you right now. So because they're in.
But the phone keeps going every day.
Yeah. So postpone any fines until we enter.
Yeah, I can see. Yeah.
That's fine.
Okay,
Yeah.
okay.
So where do we start?
That you-
20 years ago.
Mr. Chairman, if I may, I've had the opportunity to confer with counsel. Right now, I would have to advise you that you don't have jurisdiction on this TUP because they can't get a TUP when she's just represented. She's going for an SUP without a compliance agreement. So we would request jointly that the board grant a 30-day continuance. Staff will sit down with the applicants to try and work on a new compliance agreement, which in the event they have to come back for TUP, will at least eliminate the legal bar to it, and you can decide it on the merits.
Thank you, Wayne. With that said, is 30 days sufficient? Believe so?
Mr. Chairman, I believe the 30 days only requires us to have an executed compliance agreement.
Correct.
Okay.
And so if you were to do that, that date, the corresponding date for the board would be May 18th.
May 18th. All right. The applicant had come up to speak, and I didn't want to not give you that opportunity for your due process. Is there something you'd like to state at this time? If nothing else, if you're good with the continuance, that could be your request.
I'm good with the continuance, but I just wanted part of this to be clear that this is just for parking. That's all we're wanting to do. And it's in a completely enclosed agricultural exempt shop. You cannot see it. No freight comes in, no freight goes out. It leaves 3 to 5 times a month, and then it comes back and it parks. And that's the extent of it. We don't house material. We don't bring in material. It's always empty. We have the ability to park at the truck stop, but we have great pride and we've spent a lot of money in our equipment that we do use for the farm because we also have cattle and we run cattle trucks. We bring in dairy bales for the cattle. It's always open to vandalism at the truck stop, theft. And when we have a completely enclosed shop just to park, that's why we wanted to do the temporary use. Obviously, we could have done the special use. I thought the step was get the temporary, and then while you have the temporary, you get the special use. I must have been wrong on that aspect. But I just wanted to be clear that it's just only for parking, that we don't keep product and we're on 10 agricultural exempt acres, and we have great pride in our property. It's spotless. There's nothing here, and you cannot even see the truck from, not to mention there's semis all over the neighborhood. I mean, all over the neighborhood.
Understood. But going back to Mr. Peck's comment and looking also at your legal counsel, you're good with the continuance because it sounds like it's out of our jurisdiction today to even act on this.
I have one more question. This is my husband. He has one question.
Oh,
Please.
hold on a second. All right. So, Secretary, if you could provide your name and keep this as brief as you can.
Yes, sir. My name's Sean Hawley. I live at the residence. Talking about parking the truck elsewhere and not on the property. In our current area, in the unincorporated area of Maricopa County, the parking ordinance isn't enforced. Okay, so we could park that truck in front of our house on that street or in front of anybody else's house legally today and not have a problem until it's petitioned by the residents and approved by Maricopa County Department of Transportation. And then they're ordered to, in fact, post that by the Board of Supervisors. So in any one day, wouldn't you rather have a vehicle parked inside of an enclosed building than you would on the street in front of your house? I mean, it's,
I may not disagree with you, and most probably would agree with you. However, it sounds like we're limited today to a continuance option because it's not, seeing Wayne nodding yes and Darren as well. So with that said, was there anything else you wanted to add to this?
question. So during this continuance process, we're going to be working with Darren, I would imagine.
Daniel, raise your hand, Daniel. And Darren,
Darren, do we get to work with this gentleman here?
your attorney can. Attorneys play best with each other.
Okay, good. I just want to know. Thanks very much.
Thank you. All right, with all that said, I will entertain a motion for continuance to the next Board of Adjustment hearing, which is May 18th.
Do you mind since I started this thing?
Go right ahead. Oh, yeah, 'cause it's at 5. It's all right, though.
Is this yours?
I think it's 4, but go ahead. Go ahead.
No,
Go ahead,
it's
Fern.
5. Oh, I have a question. I just typed it. Can we ask that the fines cease during the 30-day process?
I apologize, Fern. I couldn't hear you very well.
I'm sorry. I thought during one of the last questions, Mr. Peck said that fines are still accruing. And I'm wondering if we can also ask during the motion that the fines cease during the 30-day process.
I don't think it's our purview, but go ahead, Mr.
You
Peck.
cannot because the hearing officer ordered the fines. Sometimes the hearing officer will say, if you come into compliance by X date, then those accrued fines are waived. This did not, that is accruing, but that can be taken care of if they enter into a new compliance agreement. So I believe staff is hearing you loud and clear, Member Ward.
Okay, thank you.
It was a great comment. All right. Any other questions or comments before we seek the continuance motion? Member Schwartz, go ahead.
Normally, but it's not in my district, so I'll wait for.
Member Ward,
I'd like to motion that we grant a continuance for 30 days on
to May 18th.
to May 18th on item number TU 2023014.
Thank you. We have a motion for a continuance to the next board meeting, which is May 18th by Member Ward. Is there a second?
Second.
Second by Member Person. Rosalie, would you please take a roll call vote?
Member Cardin,
Yes.
Member Schwartz,
Yes, and if I could make one comment real quick, that I think that this is just a procedural thing, and I know that you'll be in good hands working with staff and getting this rectified. You're correct, Mr. Hawley. I would prefer seeing it inside than out on the street, but there's procedural things, and getting into that agreement and getting the fines dealt with will just help move this thing along. Okay, so best of luck to you, and thank you.
Member Ward,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, that's a continuance by a vote of 5-0.
Thank you. I just realized I may have messed something up. It was an open public hearing. If there are folks that wish to speak, should I have allowed that, or if we've made our motion? Get comment from Mr. Peck, because I do see that there was someone who wished to speak.
We're not aware of anybody else here to speak.
Oh, okay. Online.
I'm sorry.
Wayne, so we didn't properly close the public hearing, and there is someone who wished to speak in opposition. We've made the motion and approved it to continue this. Should I take comment?
A motion to continue, it takes precedence. You can do it at any time, and you did.
Okay.
If you wish to hear from the member of the public, you can, but it really wouldn't be part of the record for that hearing. That has been moved, and that person is free to present those comments if it comes back on May 18th.
Okay. All right. Then
Like a motion to adjourn, which is always in order.
Right. All right. Thank you. Then we'll proceed on to the next item, which is BA 2023-002.
Thank you, Chairman Loper and members of the board. Case BA 2023-002 is for the Straight Living Trust property, which includes a request to obtain a variance for a proposed attached storage shed. Next slide, please. So the property is located at 38314 North 15th Avenue in the Daisy Mountain area. This is a flat 1 acre rural 43 parcel with a single family residence. Of note is that the property takes a pentagonal home plate shape. The site is accessible by way of a 20-foot easement, which ends in a cul-de-sac that intersects with the 2 east lot lines. For this reason, the 2 east lot lines are effectively front lot lines with setbacks measuring 40 feet from each. A planned storage shed would be located 22 feet from one of these front lot lines, hence the variance request. Next slide, please. So here are some photographs of the property showing the planned shed location. The one on the left is looking east toward the shed site, whereas the 2 on the right are looking south. Next slide, please. Same thing here. The 2 on the left are also looking south, whereas the 2 on the right are looking west-northwest, with the shed being proposed just on the opposite side of that wall. Next slide, please. So the last photograph is taken from the spot where the shed would be built, looking west toward the rear yard. Next slide, please. So this last slide shows an aerial of the property with the shed being planned just north of where you can see that car parked in the driveway. There appear to be viable alternative locations where the shed could be built and still meet regulations. For example, if the shed were built 60 feet further west, it would meet the requirements for accessory structures without displacing existing vegetation. And while this would place the shed partially within the rear yard setback, MCZO Article 1106.2 allows this so long as it doesn't come within 3 feet of the rear lot line and all accessory structures don't occupy more than 30% of the yard. Even with the 2 existing accessory structures factored in, the shed would meet these requirements. Alternatively, if the shed were built 25 feet further north and 35 feet further west of where it's currently proposed, it would not displace any vegetation nor encroach on any setbacks. Staff notes that there had been public comment received on the request, with one in opposition arguing that there is no hardship present on the lot to justify a variance to the zoning regulations. Based upon what the applicant has submitted and the staff analysis, staff finds that the request fails to meet the statutory test for variance approval. However, if the board finds that the applicant has proven entitlement to the variance, then the board must state on the record the basis for that determination with findings and conclusion in a motion to grant the relief sought. In such event, staff would offer the following to memorialize the variance approval. Item A, variance approval establishes a 22-foot east setback line for APN 211-50-048S. At this time, I would be happy to answer any questions.
Great presentation. Thank you very much. Are there any questions of staff at this time? Not seeing any from Member Cardin or Ward. I do have one. Was that your finger pointing in those pictures?
No, it was not.
Okay, just curious. All right, go ahead and open the public hearing. Is the applicant or applicant representative available? Please come up, provide your name, and then proceed with your presentation.
Hello, I'm Shannon Miller. I'm the contractor representing my customer. You can see they got 2 horse trailers parked on the other side of where that shed would be. If we move that shed, they have absolutely no access to get their horse trailers in and park them. It would put the shed right in the middle of that lot where there's no access to get their trailers in. They have to be able to get their trailers into this lot and to park them. That is the only access to get big trailers in is on that side. Had this be a rectangular lot, we would be well within our setbacks. The odd shaped lot is what is affecting us on this. The block walls that are on both sides will prevent any neighbor from even seeing this building. It's only 10 foot tall. It's not big. It's not a big building. It's just a storage unit. It's simply just an odd shaped lot that's preventing us from being able to put it where we want it.
All right. Are there any questions of the applicant? Member Schwartz, go ahead.
Sir, could you, I'm trying to understand the circulation of, you just brought up your circulation of your trailers getting in and out. So what would be what's the circulation flow right now?
So they enter to the right-hand side right there. There's a gate right there into the block wall. Okay, and so they have to pull up into that corner to back it in right there next to the wall. Okay. So if that shed is moved, there's no access to get the trailers in at this point.
So I guess if you moved it to the alternative location, where would that actually be on that?
It'd basically be right in between those two big trees, right where they have to drive to, right in front of the trailers is where it would be.
Okay. So are you driving the trailer in? Are you backing the trailer in?
They have to drive it in and back it up into that spot. That's the only way to get it in there, into that spot. So if
you can't back the trailer into the lot.
you could, but it would still, if the shed was there, you still can't get it in there to park it.
Okay, thank you.
Any other questions of the applicant this time? All right, hang tight. We may have some more. This is a public hearing. First, ask, is there anybody here in person who wishes to speak on this item? Seeing none, I'll ask our IT team, is there anyone online who wishes to speak? All right, go ahead, and there is none. Go ahead and close the public hearing. Turn it over to the board members for discussion and or possible motion. And as part of that, Nick, would it be possible to roll back to the site plan?
Yes.
Member Person, go ahead.
Nick, I have a question about the shed. I believe in the city of Phoenix, there is a threshold where if you don't exceed a certain square footage, then you can have an accessory structure wherever you want. I'm just wondering if there's something similar in Maricopa County that would allow them more flexibility.
Member Person, I believe, I could be wrong, but I believe it's 200 square feet. In this case, the accessory structure is 513 square feet.
Mr. Chairman, Member Person, our ordinance doesn't require a zoning clearance or construction building permit for any building under 200 square feet, but there are caveats. They still have to meet the zoning district requirements, which are setbacks and lot coverage.
Okay, thank you.
Thank you. Any other questions of staff or the applicant?
I also have a question for the applicant.
Yes, go right ahead.
Hi there. Would it be possible to have the shed located just north of the house, kind of where you're saying the trucks park now, and then the trucks park just north of that? So almost reverse of what staff was suggesting.
Put it further to the north.
Here, can I show a picture?
Sure.
Okay, I don't know how to then make this the record, but.
Give it to Rosalie.
Sorry. To locate it right there, there would be absolutely no access to get to the shed. Yeah, you couldn't even get the truck to put things in it because of the tree right there. So yeah, it doesn't really work right there either.
Yeah, I was thinking the tree would be.
The tree is a big problem there. Yes, ma'am.
Moved or.
Yeah, and that big tree does, yeah, it's a very big, nice tree, and they do not want to move that.
Thank you.
All right, thank you. Any other questions of applicant or staff at this time? Seeing none, I'll turn it over to the board for additional comment and or a motion. I did want to note, where is your alternative septic field?
It's in the front of the lot on the south side. You can see it right there underneath the tree on the
existing septic, but there's an alternative location. Just curious where that was. I imagine it's proximate to that.
And I built the barn that's over the pole barn in the corner as well. You know, everything, we've done a lot of work on this place, and there's just not really another location to put this to where they can still get their trailers in and out.
Thank you. Any comments?
I'm not going to be in favor of this because I think that there's alternative locations here, and I don't think that they've demonstrated that there's a peculiar condition. I mean, if a tree's in a way, then you move the tree. There's ways to comply with the ordinance on setbacks. And certainly, I've owned long horse trailers before, and I've been in situations where I'm just going to back things in and back things out. So I'm just not going to be in support of this case.
All right. Any other comments from any? Member Ward? Did you have anything? Member Cardin? Member Person?
Yeah, I hate these pentagonal lots because I know they create challenges, and I can't say that I've ever driven a semi truck, and I probably never will, so I can't appreciate how difficult it is. But I agree with Member Schwartz that, you know, I think it would be nice to explore some other options, and my inclination would be to make a motion for denial. But if it's something that you want to take some time to chat with staff more, I'd be happy to make a motion to continue it so that you could work through that.
We'd be up to talking. Like I say, there's not really a whole lot of other options on moving this thing. But we'll sit down and talk to the staff if there's something we can figure out. I mean, we just would like to. They simply just want a storage shed. I mean, if the lot wasn't shaped like that, we wouldn't even be here because we'd be within the setbacks. So it's just simply a misshaped lot that it unfortunately affects my customer being able to use their lot.
And thank you very much. And I would add that I actually consider the lot configuration to be a hardship because it gives you the extra frontage. But I'm also supportive of a continuance for additional time to try to see us through. This is in District 3. Is there a motion?
Well, it is in my district, but, you know, I mean, I want to be helpful. I kind of just shared where I am with my motion. If you guys think, you know, Jeff and I have kind of shared our votes, but I'm happy to let someone else make the motion. Move to approve it.
I'll make a motion. Chairman Loper.
Go right ahead, Member Cardin.
I move that we approve BA 2023002 as requested.
We have a member, all right, member, we have a motion for approval by Member Cardin. Is there a second?
Second.
We have a second by Member Ward. Rosalie, would you please take a roll call vote?
Member Cardin?
Yes.
Member Schwartz?
No, and I just want to add one comment that the lot was purchased knowing the configuration. It is not, it was knowingly purchased knowing the configuration of the lot. The lot didn't create the problem. You knew that the problem existed with a lot that was an irregular shape. And so I'm going to vote, again, like I said, vote no, and this is not a peculiar condition, and there's other options that could be looked at to resolve this without this board interfering.
Thank you. Go ahead, Rosalie.
Member Ward?
Yes.
Vice Chairperson?
No.
Chairman Loper?
Yes.
Chairman, that's an approval by a vote of 3-2.
All right, move on to the next item, BA 2023-009, the Eli property. Turn it over to staff for presentation.
Chairman Loper, members of the board, agenda item number 6 is for subject case BA 2023-009, which is a variance request for an RE43 zone property located at 26408 North 102nd Avenue in the Peoria area in Supervisory District 4. As written in the staff report, approving this request would have the effect of allowing for a proposed rear yard coverage of 42% for a detached accessory building within the required rear yard, where the maximum coverage is 30%. To allow for the relocation of a permitted but unbuilt combined pool cabana, detached garage, and covered patio structure. Next slide, please. The parcel was first developed around 2003, and the current owners took possession of the property in 2018. The lot itself is nondescript and is of typical suburban houses of suburban houses in the Northwest Valley, with no hillside or flood encumbrances. Next slide, please. In February of 2022, the owners applied for a permit to develop the subject structure. The first site plan submittal of the permit application showed rear yard lot coverage of 41.5% and a rear and side yard setback of 6.5 feet at the southwest corner. This first site plan is what has been submitted for the variance application. Next slide, please. Subsequently, the site plan was revised and the permit was issued in June 2022 at a rear yard coverage of 29.9%, just under the 30% maximum, and with a rear and side yard setback of 7.2 feet. Next slide, please. The existing rear yard setback allows for a little over 1,800 square feet of coverage by any building or structure. At 29.9%, the permitted structure covers approximately 1,795 square feet of the rear yard. The proposed structure would cover 2,493 square feet of the rear yard. Both the permitted and proposed structure are the same size and square footage. The variance request would simply be to move the structure south from the lot more towards the rear. Next slide, please. Staff would note that the applicant has also made a request for a rear setback requirement of 6.5 feet to match the location of the proposed structure. This request is invalid, as any detached accessory structures are allowed to be within 3 feet of any rear or side yard setback. Next slide, please. Staff is recommending denial on BA 2023-009 for the following reasons. The applicant has failed to demonstrate that there's a peculiar condition facing the property because the lot is compliant with Rural 43 lot standards and is not encumbered by topographical constraints such as hillside or flood conditions. And the applicant has failed to demonstrate that the strict application of the Maricopa County Zoning Ordinance to the applicant's property has caused undue physical hardship that prevents the development of the property. The owners have already received a permit for the same structure, but in a slightly more northern location. The applicant also has other options to comply with the ordinance, such as building a smaller structure or redesigning the structure to be less within the rear setback. And with that, I'm happy to answer any questions.
Thank you, Mr. Landis. Good presentation. I do have a question, but I'll see if any of the other board members have questions of you at this time. All right, seeing that, here's my quick question. So they're detached structures, so the rear yard coverage comes into play. If they attached it, however means that was, then the setbacks become the issue.
So could you repeat that one more time?
As presented, it's a detached accessory structure. It exceeds the lot coverage for that rear portion. If they were to attach it in some manner so it became part of the principal structure, their issue would be then setbacks, but not lot coverage.
Chairman Loper, that's correct. The primary structure of the lot is much more northern than the detached accessory structure. It's I don't have an exact measurement, but it's a fairly substantial distance.
Okay, thank you. Go ahead and open the public hearing. The applicant or applicant representative here, if you please provide your name.
Chairman Loper, members of the board, my name is Greg Seipt. I'm an attorney and I represent the homeowners, the Eli's, who are not able to be here today with me. Apologies, the hearing was scheduled on a date that they had business travel plans. So essentially, it's exactly right. The question that's posed for the board's consideration today is one of location of the proposed buildings on the site plan. The existing ordinance provides for an allocation of only a 30% lot coverage for the proposed buildings to be built on, where the structures that are proposed to be built exceed that by about 11.1%. In terms of square footage, what the proposal is for the board's consideration today is to increase that permitted square footage from 1795.22 square feet within that building envelope that was depicted on the slide by only 692.88 square feet, moving that back southward on the lot into that building envelope, which would increase it from the 29.9% approved to roughly 41.1. The reason for the necessity for that are a couple of different ones. I'll start with the aesthetic. From an aesthetic standpoint, if we can look at the slides, next slide, please. Next slide. Next slide. Okay. The photograph depicted in the slide here, board members, is of a tape measure that illustrates where the post for the cabana, the pool cabana, coverage would be placed. It's in the middle toward the edge of the walkway that's circumferences the pool, and there's a rock grotto behind the pool on the south side of the pool that it would encroach with. So you have the pool patio area, and the post that supports the roof for that patio area would be in that walkway. The way that the garage is constructed, from a pragmatic standpoint, is only in size to be able to house the equipment that's projected to be in there. It's currently sitting in the backyard of the property, and it's sort of an eyesore, if you would, for the other residences around. There's an RV, there's a 30-foot stacker trailer that attaches to the RV. These are pieces of equipment that my client uses in his business, and parks them there on site when they're not in use, so that, because there's issues of theft chances and whatnot if we were to leave it at the business address. The stacker trailer is 30 feet long. The RV that pulls it is 42 feet long. So there's a need for an oversized covered garage in that back area of the size that we have planned for 80 feet, and garage doors on both the west-facing sides of the garage and north-facing sides of the garage. So in order to be able to move the equipment in and out of those facilities. As staff noted, the proposed construction to move the location of the building into the footprint is still in compliance with the rear and side yard setbacks of a minimum of 6.5 feet. The only variation or deviance that we're looking for is to increase the building square footage from the 30% to the 41.1. It would increase the value of the property, both and create a situation where you don't have eyesores for the public who have to look over and their neighbors who have to look over the walls and see what is in the backyard. And so we propose that from a pragmatic standpoint and an aesthetic standpoint, that the variance be granted, so in order to allow my client to be able to park his equipment in the building and house that equipment in a safe environment, and also not to provide for a trip hazard in the walkway around the pool for the kids that run around and whatnot, with a column in the middle of the walkway, where if we just push it back slightly, it would obviate the need for any or reduce the risk of any such injury from occurring. We are also open to other suggestions on compromises if the board or staff can propose any. We're certainly here to collaborate. We're asking for permission in advance of doing any building, and not excuse for having done so without permission. Any questions I will entertain now.
Thank you. Are there any questions of the applicant? Member Person?
Thank you for your presentation. I was getting lost a little bit when you were talking about the setback, because we clarified that since it's an accessory structure, we're really talking about the area. So if I'm understanding correctly, I think you're saying you would need to shift it to that 15 feet in order to get to the 30% coverage?
No, I believe that all we would need is on the approved plan, if we can go to that slide, or rather not the approved plan, the proposed plan, the nearest setback would still be 6.5 feet from either the rear or the side walls. So within the 3 foot is the maximum.
Because what I was wondering, you've got, like, simplifying it, 3 boxes, right? You've got the one on the left is for the RVs, I'm guessing.
Correct.
And then you've got the 2 others. I was wondering, when you were asking about, potential different solutions, if you could take the RV box and shift it north, so you're getting, you're thereby reducing some of the area that's in that setback. I wonder if, I'm somewhat of a mathlete, but I can't go that fast. I'm wondering if you can shift it north far enough, leaving the other two boxes where they are so that you can get back down to that 30%. And then you wouldn't need the variance.
That's a very good question. And I think the same proposal was made by staff in the report and recommendation, if I understand it correctly.
Great minds think alike.
And to answer those two questions, so there were two options that were recommended or rather raised in staff's report to the board. And one of those was to either shift the location of the buildings forward, which would be northward in direction if you're looking at the lot, or reduce the size of the buildings themselves. I've addressed the second proposal, which would be to reduce the size. It just wouldn't be feasible to do that given the space constraints and the needs for the space. The pool cabana itself is very small. It's only, it's 24 by, 24 by 48 or something like that. It's very small, so it's only enough space to allow the housing of the pool equipment and also the changing in and out of pool clothes and whatnot. On the issue of moving the buildings northward, if we shift the entire footprint to where the currently approved plans are, that gives us what we've shown in the slide is the encroachment with the pool grotto and the walkway that extends behind it around the pool area by putting the.
Yeah, I was wondering if you just moved the RV garage part, just the west box, and left the other two exactly where they are. So, that, because I think that pool equipment area, yeah, so if you took, because you can see the cross-hatched areas, right?
Yes.
If you took number 11, just number 11, and shifted that whole thing north, then the larger of the two rectangles thereby becomes smaller, right? Because the portion that's south of that dashed line that would then be cross-hatched would be smaller.
I see your point, yes.
So that's what I was wondering, if there was a way to just move that. It doesn't seem to have the same conflict with the pool cabana and the covered patio that number 22 does.
Well, on this slide, it doesn't clearly show it. I'm wondering if there might be another slide where I have a picture. I don't think I have a picture of the pool grotto and walkway area. The drawings are not exactly to scale. So even on the approved plan drawings, it doesn't show that the pole would actually conflict. The support structure for the pool cabana would actually conflict with the walkway when it does. In fact, if we measure out the lot, the footprint of the construction, the proposed construction, I think, as I recall, if we do shift, because I addressed this with the contractor, I had him here today. I think he had to step out for an 11 o'clock meeting. We talked about other options that we could propose. One of those was potentially shifting, as you mentioned, the building number 11, which is the larger RV garage, northward. If we were to do that, the corner of the building still conflicts with there's a raised seating area adjacent to the pool that's constructed of fill and block material that it would conflict with it, depending on how far forward we go with it. We may be able to move it somewhat. I don't think it would still, as far as we could move it forward, it still would not comply with the 30% maximum building envelope requirement in the rear yard. We would still need some leeway from that. But as I mentioned, we are willing to compromise and certainly open to suggestions on how we might do that. If there is some way where we can split the difference, for example, and not go 11.1%, but maybe 5.5%, we can find some way to, in a combination of things, shrink some of the building footprint and also move it forward slightly to accommodate.
Thanks. No, that was helpful. And sorry, I'm dominating the conversation.
Hey, before we go to any other questions, somebody told me years ago not to design things at the dais, and I would hesitate to. I appreciate the spirit of the compromise, and I much prefer that than potentially a denial. But I'm inclined, and I don't know who else wants to speak on this. of possibly continuing this to allow you to, rather than say, well, we might be able to make 3 feet work or 6 feet or whatever, to sit down with Mr. Landis and Gerard and the rest of staff and try, and your client and your contractor, try to figure out what the minimum, you might figure out that you don't need any variance at all. But I think this board has always shown great appreciation for you working with them and coming back, and may not still meet the statutory requirement, but you'd be able to tell the same 5-member board, you know, we tried and we were able to reduce this, or we weren't, and here's kind of the why. So that's kind of what I'm leaning towards. I want to see if there's anybody else that has questions of you, and if there's anybody else who wants to speak, then we can address the continuance, potential continuance part of it. Is there any other board member has any questions of the applicant at this time?
Yes.
Go ahead,
So I would concur with the chair that it's hard to design something not knowing what you're designing to, and really appreciate your willingness to try to come up with a solution, because we try to all find, I think, solutions at times to help all the applicants achieve their goals. We don't want to be obstructionists.
Sure.
So I would agree that if you would, I would like to move to have a continuance so you can sit down with your designers and what you're actually going to be needing inside that building, and then sit down with staff, and I'm sure that you'll be able to figure out what you really need versus what you don't really need, need versus want. And then if you need to come back to us, then at least we know that you've made, done everything in your power to do so. And you may find out that you don't need all of it and don't even need to go through this process. So that should just be my comments and recommendation.
Any other questions of the applicant at this time? If you could hang tight for a minute, and let's see if we have other speakers. Is there anyone else in the audience who wishes to speak on this? Yep, this is the one. There's a Jim Morrison, that was your contractor, and he's not here.
And by the way, Chairman Loper, I just received word from my paralegal who was here with me today as well, that in answering or addressing the question on whether we can move building 11 forward, it's not feasible. He was telling her he's on the phone with another client at the moment, so he couldn't speak to that, but that's what I'm told. But again, like I say, I mean, in speaking with my client about the matter, he's willing to try and find some compromise grounds on which we can make things work. So.
I would feel most comfortable that way. All right. Is there anyone else in the audience who wishes to speak? Seeing none, is there anyone online?
Chairman, we don't have anyone online to speak on this case.
All right, no one online. I'm going to go ahead and close the public hearing and open it up to the board for discussion and or a motion. This is in District 4, which is my district, but I'd be curious if there's any discussion from any of the board members prior to me making a motion. All right, I'll go ahead and I'll move that we continue this item to the next regularly scheduled meeting of the Maricopa County Board of Adjustment, which I believe is May 18th.
I'll second that.
Oh, I'm sorry. What's that, Wayne?
Did the applicant agree?
Sounded like he agreed.
We agree.
Gotta make sure we get that on tape.
Yeah, there's a second.
And all right, so motion by me and a second by member Schwartz. Rosalie, when you get a chance, could you take roll call, please?
Member Cardin,
Yes.
Member Schwartz,
Yes.
Member Ward,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, that's a continuance by a vote of 5-0.
Best of luck, and we hope if we do see you back at something, thank you.
Chairman Loper, members of the board, I appreciate your time and consideration.
Thank you very much. Move on to the last item on our agenda, which is BA 2023-014, Desert Palms Presbyterian Church.
Mr. Chairman, we are not aware that the applicant is present, either in person or online.
I was wondering about that.
Yeah. Do we have anybody online? No. So we know now from our bylaws that that's an automatic continuance. So District 4, I would move that we continue this item to the May 18th Board of Adjustment.
Second.
Second by member Schwartz. Yeah, do we even have to vote? 'Cause it's part of the bylaws. We should.
You made a motion to.
Okay. We're stuck with it.
All ayes. Aye.
Yeah. I can always vote no. All right, that's approved, the continuance. I heard distinctly 5 ayes and 5 raised hands. And roll call. All right. I was getting to that. Rosalie, if you wouldn't mind.
Member Cardin,
Yes.
Member Schwartz,
Yes.
Member Ward,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, that's a continuance by a vote of 5-0.
All right, thank you. Anything additional from staff?
No, sir.
Nothing from any of the board members to staff? All right, we are adjourned.
Thank you.
Thank you.